Does Canada belong to America, or did natives give it away? The historical truth everyone gets wrong. Hi, I'm Jake Wilson, and today I want to share my analysis of something fascinating that happened in my comments section. Two viewers left completely opposite claims about Canadian territory, and here's what's incredible. They're both completely wrong. But their mistakes reveal the biggest misconceptions people have about North American history. This is educational content based on public sources, and I'll be sharing my analysis of documented historical records. One commenter wrote, "Canadian land belongs to America." Another replied, "No, Native Americans gifted these lands long ago, which became Canada." Both comments got hundreds of likes. Both represent widespread beliefs, and both are contradicted by 250 years of documented legal history that most people have never seen. Here's what actually happened, and why understanding this changes everything you think you know about sovereignty, Indigenous rights, and how borders really work in North America. The first big lie: Canada belonged to America. Let me be direct about this claim. According to historical records, Canada was never legally part of the United States. Not for a day, not for an hour, never. But this myth persists because people don't understand how colonial territories actually worked. Before 1783, what became Canada and what became the United States were both British colonies. But here's the key detail everyone misses: they were administered separately. The British didn't see them as one big territory that would naturally stay together. They were distinct colonial regions with different governance structures. When the American Revolution happened, the Treaty of Paris in 1783, and I'm looking at the actual document here, established the first formal boundary between the newly independent United States and British North America. That British North America would eventually become Canada, but it was never American territory. Benjamin Franklin actually demanded the cession of Canada during those 1783 peace negotiations. Britain refused. The Articles of Confederation included an open invitation for Canada to join the United States. Canada never accepted. During the War of 1812, this is documented in military records, American forces invaded Canada at 3 separate points. All 3 invasions failed. Thomas Jefferson had predicted conquering Canada would be a mere matter of marching. He was spectacularly wrong. The Treaty of Ghent in 1814 restored what historians call the status quo ante bellum. Everything went back to how it was before the war. No territorial changes, no American expansion into Canada. In my analysis, this is where the myth starts. Americans assumed they would eventually absorb Canada through natural expansion. When that didn't happen, some people kept believing it should have happened, creating this persistent idea that Canadian territory somehow belonged to America. But the documented legal reality tells a different story. How Canada actually became sovereign. According to government archives, Canada became sovereign through what historians call constitutional evolution, not revolution. This is a completely separate legal path from American independence. Here's the timeline that most people have never seen. French colonization from 1534 to 1763 established New France. Jacques Cartier claimed territory for France in 1534. Samuel de Champlain founded Quebec City in 1608. By 1760, approximately 70,000 French inhabitants lived in the colony. The British conquest in 1763 followed the 7 Years' War. The Battle of the Plains of Abraham in September 1759 led to Quebec's fall, and the Treaty of Paris on February 10, 1763 formally transferred New France to Britain. Here's a crucial document most people don't know about: the Royal Proclamation of 1763. This explicitly recognized Indigenous land title and established governance for the new British territory. We'll come back to why this matters for Indigenous rights. Confederation on July 1, 1867 created the Dominion of Canada through the British North America Act. This united Ontario, Quebec, Nova Scotia, and New Brunswick. But this wasn't independence yet. Britain retained legislative control and managed Canadian foreign policy. The Statute of Westminster on December 11, 1931, granted Canada legislative equality with Britain. Historian A.R.M. Lower called this date as close as was practical without revolutionary scissors to legislating the independence of the Dominions. Full constitutional sovereignty arrived on April 17, 1982, when Queen Elizabeth II proclaimed the Constitution Act, ending British Parliament's authority over Canada. In my view, this gradual evolution explains why some people get confused about Canadian sovereignty. It wasn't a dramatic break like American independence. It was a slow constitutional process spanning 115 years. The second big lie: natives gave away the land. Now let's examine that second comment about Indigenous peoples gifting or giving away their land. According to court documents and historical records, this claim is equally false, but for completely different reasons. When Europeans arrived, some sources indicate that approximately 500,000 to 2 million indigenous people inhabited what is now Canada. These weren't scattered tribes without governance. They were hundreds of distinct nations with sophisticated political systems. The Haudenosaunee Confederacy operated under the Great Law of Peace, a constitutional framework that predated European contact. The Anishinaabe Council of Three Fires governed territories from the Ottawa River to Saskatchewan. The Mi'kmaq controlled Atlantic coastal regions. Here's what's crucial. These nations had complex systems of land management and territorial boundaries. They weren't primitive societies lacking concepts of land tenure. They were organized nations with collective land systems that were fundamentally different from European individual property ownership. The Royal Proclamation of 1763, sometimes called the Indian Magna Carta, formally recognized this reality in British law. It declared lands west of the Appalachians as Indian territories, where First Nations should not be molested or disturbed. What actually happened in the treaties? This is where the story gets really interesting, because there's a massive gap between what Indigenous nations thought they were agreeing to and what colonial governments claimed they had acquired. According to documented sources, Indigenous understanding of treaties centered on sharing, not surrender. In Anishinaabe-Moan, treaties were called Agawidi-Winan, bringing things together. In Cree, Kichiasodamatuan means sacred promises to one another. Carl Quinn, a Saddle Lake Cree elder, explained in documented interviews, "The way that Treaty 6 was written was not what was agreed to. We agreed to the sharing of the land, yes, and we told the Europeans to only take what you need from the land." The concept of owning or selling land didn't exist in many Indigenous languages. When Indigenous leaders agreed to treaties, they understood them as agreements to share territory with newcomers while retaining their rights to hunt, fish, and live on the land. But Crown interpretation treated written treaty text as complete agreements where Indigenous peoples had ceded, released, surrendered, and yielded up all lands forever. Here's what the historical record shows about these treaty negotiations. Treaties were written exclusively in English, with inadequate translation of complex legal terms like cede, surrender, and whereas. Indigenous leaders couldn't read English and received no independent legal advice. Negotiations were completed in days, not allowing proper community consultation. Government of Canada archives acknowledge, and I quote, "In some instances, Aboriginal groups voluntarily surrendered their Aboriginal title, but in other instances fraud, undue influence and misunderstanding would seem to invalidate the arrangement." The context nobody talks about. The numbered treaties covering most of Western Canada were negotiated during a period of Indigenous crisis. By the 1870s, buffalo populations had collapsed, epidemics had decimated communities, and starvation threatened survival. According to documented sources, Indigenous peoples negotiated from positions of increasing desperation, not equal bargaining power. After Treaty 6, within a decade, a pass system was introduced requiring Indigenous people to obtain permits from Indian agents to leave reserves. Leaders who resisted treaties, like Big Bear and Poundmaker, were arrested. The government provided emergency relief only on condition of moving to reserves. Sacred ceremonies, including the Sundance, were banned. In my analysis, this context completely undermines any claim that Indigenous peoples voluntarily gave away their land. These were coerced agreements made under duress, often involving systematic misrepresentation of what was being agreed to. The massive territories that were never ceded. Here's something that will surprise most people. Vast portions of Canada have no treaties at all. Most of British Columbia, approximately 95% of the province, remains what legal scholars call unceded territory, where First Nations never signed away their lands. The peace and friendship treaties between 1725 and 1779 between the British and Mi'kmaq, Maliseet peoples in Atlantic Canada contained no land cessions whatsoever, only agreements of peace, friendship, and trade. Parts of Quebec, Ontario, and the Maritimes similarly lack treaties ceding Indigenous land rights. These aren't historical technicalities, they're active legal realities affecting land use today. How Canadian courts changed everything. The transformation in Canadian law began with Calder versus British Columbia in 1973, when the Supreme Court recognized that Aboriginal title exists as a legal right, independent of treaties or government grants. Delgamuukw v. British Columbia in 1997 established that Aboriginal title is a right to the land itself, that oral history is admissible as evidence equal to written documents, and that the Crown must consult with Indigenous peoples before development on claimed lands. The landmark Tsilhqot'in Nation versus British Columbia in 2014 delivered the first declaration of Aboriginal title in Canadian history, recognizing Tsilhqot'in title to 1,750 square kilometers. The court confirmed that terra nullius, the idea that land was empty, never applied in Canada. In August 2025, the BC Supreme Court granted Aboriginal title to the Haida Nation over Haida Gwaii. These aren't ancient historical curiosities. These are modern legal victories recognizing Indigenous land rights. Modern treaties and land transfers. Modern treaties have transferred significant land and self-governance rights that contradict any idea that Indigenous peoples gave away everything historically. The Nunavut Agreement in 1993, the largest Aboriginal land claim settlement in Canadian history, granted Inuit 350,000 square kilometers of titled land and $1.9 billion in capital transfers, ultimately creating the territory of Nunavut in 1999. The Nisga'a Final Agreement in 2000, BC's first modern treaty, granted 2,000 square kilometers and approximately $200 million with self-government authority. These agreements recognize that Indigenous peoples never surrendered their underlying rights to traditional territories. Section 35 and Constitutional Protection. Section 35 of the Constitution Act 1982 provides the foundation for modern Indigenous rights. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. This constitutional protection cannot be limited by the Charter's Reasonable Limits Clause or the Notwithstanding Clause. It's some of the strongest legal protection in Canadian law. The international context. In 2021, Federal Bill C-15 declared the doctrine of discovery racist, scientifically false, legally invalid, morally condemnable, and socially unjust. The Truth and Reconciliation Commission's Call to Action 47 explicitly called on governments to repudiate concepts used to justify European sovereignty over Indigenous lands. These aren't radical new interpretations. They're official government positions based on documented historical analysis. Let me return to those two comments that started this analysis. Canadian land belongs to America. False. Canada was never American territory. It developed from French and British colonies through a distinct constitutional path, achieving full sovereignty in 1982 after a 115-year process of constitutional evolution. Native Americans gifted these lands. False. Indigenous peoples negotiated treaties they understood as sharing agreements, often under circumstances involving coercion, mistranslation, and broken promises. Many territories were never ceded at all, and modern courts recognize ongoing Aboriginal title. According to my analysis of the documented sources, both myths serve similar purposes. They avoid dealing with the complex reality of ongoing Indigenous land rights and the legitimate but separate development of Canadian sovereignty. The America owns Canada myth ignores documented legal history and international treaties. The natives gave everything away myth ignores documented coercion, ongoing legal cases, and vast unceded territories. Understanding the real history matters because it affects modern politics, land use decisions, and reconciliation efforts. When people believe false versions of history, they make poor decisions about contemporary issues. What the documents actually show. Based on the historical sources I've reviewed, Canada followed a completely separate legal path from the United States, with documented independence through constitutional evolution, not American territorial claims. Indigenous peoples were organized nations with sophisticated governance who understood treaties as sharing agreements, not land surrenders. Vast territories remain legally unceded, particularly in British Columbia, where 95% of land was never surrendered through treaty. Modern courts increasingly recognize these realities, culminating in declarations of Aboriginal title and requirements for Crown consultation. The truth about sovereignty. Sovereignty isn't just about who claims what, it's about documented legal processes, international recognition, and constitutional development. Canada's sovereignty developed through documented constitutional steps from 1867 to 1982. Indigenous sovereignty never disappeared. It was recognized in the Royal Proclamation of 1763, confirmed in modern court cases, and protected in the 1982 Constitution. These aren't competing claims. They're overlapping legal realities that Canadian law is still working to reconcile through modern treaty processes and court decisions. Sources and further reading. All sources are listed in the description, including Supreme Court decisions, government archives, and academic scholarship. I encourage you to read the primary documents yourself. They're publicly available and often quite different from popular misconceptions. The Treaty of Paris, 1783, Royal Proclamation of 1763, and Supreme Court cases like Chilcotin v. BC are all accessible online. The Truth and Reconciliation Commission report provides comprehensive analysis of the treaty process. My analysis and conclusion. In my opinion, both comments in my section represent common but false beliefs about North American territorial history. The documented legal record establishes that Canada was never American territory and that Indigenous peoples never voluntarily surrendered most of their traditional lands. What's my take? Understanding accurate history is essential for informed discussion about modern issues like Indigenous rights, territorial disputes, and reconciliation. When we base our opinions on documented facts rather than popular myths, we make better decisions about contemporary challenges. The shift in Canadian courts represents not a rewriting of history, but a correction, acknowledging that written historical records were shaped by colonizers, that oral promises matter, and that Indigenous peoples never agreed to what colonial governments claimed they had obtained. This analysis is based on publicly available government documents, court decisions, and academic sources listed in the description. These are my interpretations of documented historical evidence. What's your view on how historical misconceptions affect modern political discussions? Let me know in the comments, and I'd love to hear if you've encountered similar myths about territorial history in other countries. Sources are listed in the description below.